So let's begin. So today we have two topics that we're going to cover. First, the legal challenges to global minimum tax under international law. And this will be covered right now by Professor Blazes, uh, who's a professor at Lazarski University, and he's also with PwC, Netherlands. So, and then after, Professor Browner will join us, and he'll talk about specific American rules, especially guilty, but also the corporate AMT and some other rules, and the relation with Pillar 2. So, without any further ado, Blazes, thank you very much for accepting our invitation and joining us. And I do want to give a special thank you to Vitor also for connecting us. It's a big pleasure to have you here. It's an honor to have you here. And the floor is yours. Thank you very much.
Thank you so much for invitation. It's always a pleasure to share my thoughts with friends from Brazil. I've been a few times at the IBDT. So the topic is, as you see, quite broad because I don't restrict myself to tax treaties or any source of international law, but all relevant sources of international law. And the legal challenges can be intuitively connected with dispute settlement, with jurisprudence, with case law. But I want to broaden your perspective and think about it as also relevant for governments and tax and legislators, because every state is responsible to ensure that domestic legislation is compatible with international law. And I will come back to it in the end, but I think it's also good to mention it in the start. Outline is quite ambitious, and I think that because the topic is still vastly under research and certainly misunderstood in my view, you see in point 4, I explicitly indicated questions and discussion, but it is my preference, if you agree, that if you feel that there is a burden of knowledge that is heavy to carry on by you or heavy to deliver by me, we can stop and we can ask questions on an ongoing basis. I will make such pauses, and I will explicitly ask you if you have some questions, if you would like to add something, or you think that something is maybe contrary to what you have learned from other professors or in general, please do it, and I will make such pauses. So we will start with relevant sources of international law. It is an introductory part to this lecture, but it's also very important for strategic considerations of the interplay between Pillar 2 rules and international law, and we will soon come back to that. From the perspective of sources of international law, it is always good to look into fundamentals, and such a source or indication of different sources of international law is Article 38, paragraph 1, letter A to C of the Statute of International Court of Justice, ICJ. And ICJ is located just around 80 kilometers from the place I'm sitting in The Hague in the Netherlands. So what that provision says, and additions, this square brackets are additions made by me, it's not in the law, but I made it explicit here. It says the court, the ICJ, whose function is to decide in accordance with international law such disputes as are submitted to it shall apply. And what the court shall apply? Sources of international law. To start with, international conventions, whether general, like multilateral treaties, like MLI, or in particular, like bilateral treaties, like tax treaties or bilateral investment treaties, establishing rules expressly recognized by the contracting states, right? So what is relevant for Pillar 2 challenges? Of course, tax treaties, investment treaties, and to some extent may also be EU treaties, even to non-EU member states like Brazil. Then the second source is international custom as evidence of a general practice accepted by law. And it's customary international law, very difficult to recognize, especially in respect of taxation. Therefore, there is ongoing debate whether custom may be at all relevant for tax purposes and specifically to Pillar 2. It is a debate around nexus for income taxation, which was one of the main topics at the latest International Fiscal Association Global Congress in Cape Town, South Africa. I added that it's debatable whether it's relevant or not, but everything in relation to interaction between international law and Pillar 2 is debatable. I watched a bit class that you had a few days ago with Professor Avionach, and you will see that what I think about certain issues, he probably thinks differently. So everything here is debatable. And the last source, general principles of law recognized by civilized nations. And this phrase civilized nations is very unfortunate. It's outdated and nowadays obsolete. But this law has been drafted already in 1945 or so, so it's very old, but they should change, just on margin. And here of relevance are principles of non-discrimination, proportionality, and good faith. Before even we move further, it is important to consider that there is no equality among Pillar 2 rules in respect to legal challenges. We will see that clearly that one rule is more susceptible to be challenged than another one. However, they are all interconnected. From perspective of strategic tax advice and strategic litigation planning, it's important to keep that in mind because there is a kind of, I would say, nihilistic approach represented by also some scholars, according to which it is economically not viable to challenge Pillar 2 rules, either in front of domestic courts or international tribunals, because if you prevail in one country, then this income, under tax income, will be captured by another state. I think it is very far-fetched observation. It's not necessarily correct both economically and legally, and we will come back to it. Moreover, the very fact that Pillar 2 rules are interconnected or are meant to be interconnected may equally work against them because the collapse of one rule, like UTPR, may trigger a domino effect and all rules will collapse. And we will also come back to that. Another point, another preliminary point is that not all sources of international law are equally relevant, of course. We will see that tax treaties constitute the most solid basis, but investment treaties for some countries, for example, for South Africa or for Brazil, two BRICS countries, will not be that relevant. However, it will be still relevant for Brazilian MNEs to consider investment treaty protection, and I will explain to you why. Here is a kind of map. Note that these letters are very small, but this is just to show you what is the impact of the interconnection between different rules and why it is important in strategic litigation to try to traverse from the QDMTT challenge to UTPR challenge, because it will strengthen the position of the MNE group in respect of Pillar 2 challenges. The short answer is because it is much harder to challenge QDMT or IRR, and it is easier, quote unquote, to challenge UTPR because UTPR is more prone to challenges in respect of expropriation, non-discrimination, violation of treaties, etc., etc. So we start with QDMTT. Which rule and which source of international law could be relevant here? Well, if you look at it, at least from my research, follows that mainly investment treaties, because if one country promised to foreign investor tax holidays for 10 or 20 years, which could be, which could start 10 years before Pillar 2, that anyone could think about, why now this should be abolished, right? Because a country was legally forced to do it? No, it was only political commitment. The opposite is true. The country could be legally forced to not do it because there is superior law, like investment treaty, to prohibit that because it would be violation of reasonable, legitimate expectations of the foreign investors or umbrella clause or some other clause to which we will come back. Then we have IRR. IRR may be also challenged both are under investment treaties, a bit less so under tax treaties because of similarity to CFC rules. But of course, there are differences between IRR and CFC rules. And finally, we have UTPR. And UTPR is so problematic that it can be challenged under tax treaties, under investment treaties, under customary international law, and even EU treaties. So what is the result? If you manage to push the focus from QDMTT through IRR to UTPR, or to even start with UTPR, then the result would be that taking out the negative impact stemming from UTPR to MNE group may change the entire group position vis-a-vis Pillar 2. And with some reorganizations, they may escape it altogether, especially if they are Chinese or US MNEs. Of course, it's not the case for Brazil because Brazil decided to implement Pillar 2. And as far as I know, QDMTT and IRR will apply from 2025, correct?
Incorrect.
So you
Not IRR.
incorrect. Only
QDMTT,
IRR.
yes. Only
QD
QDMTT.
entity.
Only QDMTT. Okay, only QDMTT. So here in Brazil, it's enough to target QDMTT in Brazil. But if Brazilian MNE is spread out in different countries, when IRR and UTPR apply, then of course this consideration is still relevant. It's also relevant for policy discussion. Why you have it? Was that like enough economic reasoning put it behind? Did somebody make any calculation? Was that was analysis of impact of Brazilian treaties, etc., etc. But this is mainly to UTPR. So let's start with general principles of law. We focus on non-discrimination first and then go through proportionality to good faith. But a bit, what are general principles of law and how we can apply it for the benefit of ourselves or taxpayers or tax advisors? They mostly develop through a specific branch of state power, which is judiciary power, through interpretation of law, domestic and international law. But general principles of law differ from typical legal interpretation, the goal of which is to decode the meaning from different legal provisions. So like deconstruct legal norm from various legal provisions. Instead, general principles of law are very important, informative about which method of legal interpretation serves best the purpose of decoding the meaning from different provision, and they resonate best with the purposive method of legal interpretation. They have two main functions: interpretative, mentioned before by me, and gap filling function. Yeah, so they inform about the method of interpretation. They help to recognize fundamental values that needs to be protected by law that is subject to interpretation. For example, protection against discrimination or protection against action of states in bad faith or taxpayers in bad faith, like abusive tax avoidance. If you apply them, for example, if you apply a general principle of non-discrimination, you aim to apply law so that discriminatory results shall be avoided, or the same disproportionate result. Sometimes they may also have, although it's controversial, gap filling function. It's controversial because if judge interprets law so that the gaps are filled, it is a kind of replacement for legislators, so it's a bit dangerous. But oftentimes, in respect of tax cases, the gap filling function and interpretative function merge into one and the same function, which is basically prevention of undesired results like discriminatory or abusive. For legal challenges, general principles of law, by contrast to other sources of international law like treaties or custom, cannot be applied directly to challenge, for example, UTPR. They rather are interpretative tools that allow to apply treaties or customary international law in a way that it will lead to, as I mentioned before, results that are meant to be achieved by means of those rules. So like non-discrimination or prevention of abuse. Also, if you are in doubt which results of interpretation you should pick, because you have 2 or 3 results, like UTPR is compatible with tax treaties, Article 7.1 is not compatible with tax treaties, then if you apply general principle of law, like proportionality or in good faith, it may give you idea which results should be selected and applied. Another important principle for challenging Pillar 2 rules is principle of proportionality. It's by far the most pervasive general principle of law among all of them, both in domestic and international legal orders, also in domestic and international jurisprudence of international and national courts and tribunals. It also appears in the most fundamental sources of international law, like Article 51 of the Articles on the Responsibility of States for Internationally Wrongful Acts. I will just quote it because it's brief. Countermeasures must be commensurate with the injury suffered, taking into account the gravity of the internationally wrongful act and the rights in question. Now you may wonder why I refer to that. I refer to that because violation of tax treaty by application of UTPR constitutes an internationally wrongful act. What it means? It means that a state which suffers from UTPR because its MNEs are subject to taxation under UTPR may consider to apply countermeasures. And it's not a retaliation, it's a countermeasure. If such countermeasure is applied in accordance with the principle of proportionality, then it's legal under international law. If states dispute around that, they need to find a forum to solve that dispute. And typically it's either relevant international tribunal or the second opinion rendered by the International Court of Justice. You find a principle of proportionality also in the Article 50 UN Charter, in the ICJ case law, in that case Nicaragua versus United States of America. It's a component of necessity. So principle of proportionality has 3 fundamental core components, elements: suitability of the measures, necessity, and proportionality sensu stricto, which requires to balance different interests, like interests of states and interests of taxpayers protected, for example, under tax treaties. Let's take a look a bit closely at proportionality in tax law, including global minimum taxation. So it's an exercise of balancing interests of taxpayers or investors, they often are the same in cross-border scenarios, versus interests of states, interests of tax authorities. Example from the Court of Justice of the European Union. So the CJEU applies principle of proportionality typically in cases in which there is a question of compatibility of domestic rules, for example, anti-tax avoidance rules, with EU primary law, like fundamental freedoms or principle of non-discrimination, or together. So the court first look at the domestic law, let's say QDMTT, and checks whether it's, after determining that there is a restriction or violation of free movement of establishment, for example, or free movement of capital, which is relevant to Brazil because it applies also to non-EU member states. So first, the court will look whether there is any justification to do it, like prevention of tax avoidance, abusive tax avoidance. If there is, if the measure is appropriate to target it, and if it's necessary. And originally, there was also first step proportionality sensu stricto, this balancing act, but nowadays, Court of Justice applies the necessity and proportionality sensu stricto together. And this is all to manage the tensions between different principles, right? We have principle of that protects taxpayers against uncertainty, against discrimination, but also we have interests of states that aim to increase revenue. I also have found that in Brazil, one of the judges of Brazilian Supreme Court, Orizombo Nonato da Silva, already in 1988, I think it was before the legislation of the current Brazilian constitution, stated that the power to tax cannot exceed reasonable limits, so as to constitute the power to destroy, because the power to tax can only be exercised within the limits that make it compatible with the freedom of labor, commerce, and industry, and with the right to property. And he continues. So if taxation is disproportionate, it may no longer be considered as a tax in good faith, but as a measure of abuse of state fiscal power. So in extreme situation of disproportionality, and I will come back to it soon in respect of Pillar 2, taxation may destroy investment that is source of income. Now let's consider UTPR in that context. And the question is: the application of UTPR proportional to loss-making constituent entities? Why that question? Because UTPR does not recognize between profit-making and loss-making constituent entities subject to taxation. As long as any company in the chain of ownership is under tax, either because QDMTT or IRR doesn't apply, or both rules applies, but for some reason there is still under tax, this remaining part, and sometimes it can be more than the company can afford to pay. Or what if this loss making and there is no really money to pay from because you have negative income? You have less than zero. What then? Is it proportional to apply it? Why countries designing UTPR forgot about principle of proportionality if this is most pervasive principle of law? Another question: how can taxpayers pay under UTPR without any income or with negative income losses, right? Shall we let the UTPR to globally trump a separate entity approach? Why? You will see in the expert opinion of Professor René Matteotti, I think he's also one of the lecturers, that he deals with that question. And his answer is that if a court will look at the group, M&E group, not as a whole, as a whole, then there will be no problem with UTPR, because the court will say, well, even if there is a negative income at the level of constituent entity in Netherlands, then the mother company or the ultimate parent may lend the money to pay it. But it is at odds with separate entity approach, and also it is at odds with how law and how legal responsibility applies to separate entities, right? There is no like joint responsibility for taxation unless there is a tax group in one country typically. So I think it's very problematic already. Let's move to good faith principle and its overarching importance for tax treaties. So principle of good faith, also pacta sunt servanda in Article 26 on the Vienna Convention, appears also in Article 27, an interpretative rule in Article 31, paragraph 1, which means that general principle of law has a status of codified customary international law in respect to all treaties, including tax treaties, investment treaties, even EU treaties. And it has a very strong significance for tax treaties, because tax treaties, also investment treaties, are typically bilateral. Therefore, in bilateral, by contrast to multilateral treaties, it is easier to reconstruct the common intention of two states. And this is the goal of principle of good faith, to interpret and apply treaties in order to effectuate common intention of states, not the intention of one state, like the state which tries to impose tax under Pillar 2, but both states. And maybe another state is non-Pillar 2 state. Its intention should also be respected under treaties and principle of good faith. In the commentary both to OECD and UN model, you will find explicit recognition of principle of good faith, both in respect to identification and prevention of abuse of treaties by taxpayers, but also contracting states. For taxpayers, one of the references is paragraph 59 to Article 1, in which the OECD recognizes the power of states to identify abusive transactions and to disregard them for purposes of granting tax treaty benefits. And you see explicit reference to good faith under Vienna Convention. Also, there is such recognition in paragraph 72, Article 1, in respect of states, of contracting states, which try from time to time to overwrite treaties or to underwrite them. Underwriting is a form of treaty dodging, to which we will come back because UTPR here also comes into the picture. But good faith is relevant for the interplay of Pillar 2, both with tax and with investment treaties. So just as taxpayers may abuse those treaties or investors, the same it can be said in respect to states, contracting states and tax authorities. But here we face a significant imbalance in respective rules that embody principle of good faith. Namely, we have the principal purposes test, which is a tool for tax authorities to identify abuse by taxpayers and deny them benefits under treaties, tax treaties. But we don't have anything like that on the side of taxpayers. And now when you face with such a powerful legislation, pervasive in different countries, interconnected rules, etc., like Pillar 2, such rule to create a counterbalance to PPT, I think is justified. But of course, there is a deep, deep silence about it. So now consider good faith in respect of application of Pillar 2 under tax treaties. You face with the question whether the taxation under IRR is compatible with Article 7, Paragraph 1 of tax treaties. I think Professor Aviona discussed that a bit. And try to answer that question with and without principle of good faith. Is really an analogy to CFC rules in good faith to ensure or to state that there is compatibility? If so, why differences between IRR and CFC rules are not taken into account? CFC rules typically, I know that in some countries it's different, but typically target only tax avoidance income and tax avoidance transactions. And in the European Union, it may target only wholly artificial arrangements. Nothing like that is relevant for IRR. The same question could be asked in respect of tax sparing clauses. IRR basically neutralizes the effect of tax sparing clause in conjunction with the domestic tax incentives. Is it taxation in good faith if two countries decided to include tax sparing clause in the treaty, and this inclusion stems from the common intention, and then one state intention is only respected if you conclude that IRR is compatible with tax sparing clause? Consider also good faith and Pillar 2 in respect of investment treaties. Consider a situation in which country, let's say Brazil, provided foreign investor for non-taxation or lower taxation of income in exchange of big investment, of hiring thousands of people, of bringing in to Brazil technology, etc., etc. Or also think about special economic zones. Up to 70% of developing states have one or another form of special economic zones. To enter into, you need to again meet specific precise criteria and parameters to benefit from tax holidays. And investor did that. And now QDMT enters the picture and violates protection given to foreign investors under fair and equitable treatment provision, because the legitimate expectation is violated, or umbrella clause. Umbrella clause is protection, whereas which is relevant where a country hosting investment, like Brazil in that scenario, explicitly promised investor specific treatment, typically not through legislation, but through an agreement with investor. Is it in good faith now to say, sorry, but we implemented Pillar 2, so we can't do it? Again, were you as a state forced legally obliged to implement Pillar 2? Or only politically? If only politically, should politics trump international obligation in which you willingly enter into by application of your sovereign rights to enter into treaties, which are oftentimes constitutionally higher in the hierarchy of sources of law than Pillar 2, which is domestic law? And obviously, general principles of law are also higher in the hierarchy of law, as per Article 38, paragraph 1, letter C of ICJ statute. And finally, we have principle of non-discrimination, also equality. So I will be brief here, although there is a lot of text, just to make, to explain how important that principle is. So in excellent book about rule of law and investment treaty, Professor August Reinisch from Vienna University and Stefan Schill from University of Amsterdam observed that principle of non-discrimination aligns with core values that any system of law deserving of the name, whether domestic or international, aims for. It is also, again, in fundamental sources of international law, like Article 1, Paragraph 2 of the UN Charter. You can find it in the case law of the International Court of Justice in famous Southwest Africa second phase case, in which Judge Tanaka, in his dissenting opinion, recognized that non-discrimination tracks back to Aristotle and his learning about equality. And it basically boils down to the observation that non-discrimination requires that not only the equal treatment of equals, but also consideration of differences in assessing whether different treatment is just and is geared to achieving de facto equality, not just formal equality. Is there any de facto equality between taxation of loss-making and profit-making entity under UTPR? I don't think so, but we can discuss about it. Principle of non-discrimination in certain settings, like fundamental human rights, is also considered customary international law and belongs to the sphere of obligation erga omnes, like recognized by Inter-American Court of Human Rights. And you may ask me, why you are saying about it? We are talking about taxation of multinationals. But there are people between them, and if a company is completely deprived of its assets and is not able to pay income, but still is legally obliged to do so, is it not a deprivation of right to property, which is one of the fundamental human rights? By the way, disproportionate in that case when we deal with Pillar 2. Okay, so that was the first phase, and I think it's you feel the topic a bit better. So I will pause here for a second and let me know if you want me to continue or you would like to intervene. So I shall continue, right?
Yes. They don't have questions here. I don't think we have any questions online. We can do them later, and you can go further.
Sure. So next one is prohibition of discrimination under tax treaties. So we finalize general principles of law. We go to tax treaties. So I focus only on article, which is the most important. We could go from all paragraphs, but then the entire lecture will be about non-discrimination. I'm more than happy to do it, but not tonight for me, afternoon to you. So let's look at the situation where we deal with the subsidiary, and maybe also permanent establishment under paragraph 3, basically the same intellectual construction here. What says OECD model? It says that enterprise of a contracting state, the capital of which is wholly or partly owned or controlled directly by indirectly, by one or more the residents of other contracting states shall not be subject to, in the first mentioned state, let's assume it's Netherlands, that in Netherlands shall not be subject to any taxation or any requirement connect therewith, which is other or more burdensome than the taxation and connected requirements to which other similar enterprises in the first mentioned state are or may be subjected. So imagine you have MNE in Brazil, and that MNE in Brazil has some subsidiary in Netherlands. And but I will come back now to the specific legal rule which is enforced, because of course model is not source of law. In paragraph 6, you see that non-discrimination is one of the rare provisions under treaties which applies to all taxes, not only those covered by treaties. So it applies also to wealth taxes, to inheritance taxes, to VAT taxes. You see, every kind. Why it is important for UTPR or QTMT or Pillar 2 in general? Because there are some tax experts who argue that UTPR is not at an income tax substantially similar to be covered by tax treaties. However, here you see, we follow the example. And what is the problem with Brazil-Netherlands tax treaty from 1990? Because it deviates both from the OECD and UN model in that regard. It states in paragraph 4 that the term taxation means taxes to which this convention applies. Okay, exclamation mark. So be aware, even though in 90% of treaties or more, non-discrimination applies to all taxes, not only income taxes, for some treaties it applies only to income taxes. And taxes substantially similar, like to Brazil-Netherlands tax treaty. And I do know that there is quite much business of Brazilian companies in Netherlands, so it's important to factor that in. That for purposes to get protection under non-discrimination Brazil-Netherlands tax treaty, you need to first go through the struggle to prove that taxation under UTPR is income taxation or taxation substantially similar. It's not the case for Brazil-Japan tax treaty, in which that treaty applies to every kind of description. So for the businesses between Brazil and Japan is different, right? But we'll back to that first part. So even if there is a company between Brazil and the respective treaty contracting state, which is undertaxed, and that in that jurisdiction doesn't have a tax treaty with Brazil or with Netherlands or Japan, because of this phrase directly or indirectly, it will be still applicable by Brazilian enterprise if under taxation in Netherlands or Japan through UTPR takes place, because that intermediary somewhere, it can be even tax haven, doesn't matter, is under tax. So it's important. You look at the entire group, and non-discrimination may still protect you, even without direct connection. And what is my observation about non-discrimination violation? So there are two schools of thoughts, right? First is narrow and formalistic approach to interpretation of non-discrimination. It says that non-discrimination under tax treaties applies only to differentiation criterion solely based on resident of a foreign owner or controller. And therefore UTPR is safe. It leads to discrimination, but not the discrimination which is precluded under treaties, because in addition to the residence criterion, UTPR is activated by means of two others, seemingly neutral criterion. It must be threshold of 750 million euro crossed, of course, at the group level, and also effective taxation must be below 15%. But you have the second school of thought, which I promote, which is more substance over form and broad interpretation of non-discrimination provision. And if you apply that interpretation to non-discrimination provision, then taxation under UTPR appears to be actually activated due to the tax residence of the UPE in a state without Pillar 2 rules, for example, in US or China. you may have only two countries in that quotation, in that equation, and so what? Because it's important because they are two biggest economies, so they represent vast chunk of global income. And therefore, if non-discrimination will protect their MNEs, then again, the fact that Pillar 2 rules are interconnected, it creates them a big trouble, big problem. Let's look a bit closer at the broad at substance of reform interpretation of non-discrimination provision under treaties. It also follows from the principle of good faith, which in that case requires to interpret and apply Article 24 non-discrimination provision in a way that to the fullest possible extent its purpose will be effectuated in accordance with the common intention of contracting states. For what purpose? For the specific purpose of that provision, which is to eliminate obstacles to cross-border investment and commerce stemming from discriminatory taxation. And again, we may cycle back and discuss whether it's discriminatory taxation de facto, de jure, direct or indirect, and that only direct and de jure is covered by, in respect of residency, is covered by that provision. But if discrimination is disguised in neutral criteria, like this threshold 750 million and 50% of taxation, then you take the disguise out, you take those two seemingly neutral criteria out, and with what you end up? You end up squarely with the criterion that is precluded as differentiative criterion, which is the residence of the owner or the controller. Also, the principle of systemic integration stemming from Article 31, paragraph 3, letter C of the Vienna Convention on the Law of Treaties will pull you towards the direction. Why? Because it requires you to consider, to take into account together with the context, so the contextual interpretation of tax treaties, any relevant rules of international law applicable in the relations between the parties, like Netherlands, Brazil, or Brazil, Japan. And what are those? Oh, for sure, they are principles like proportionality, good faith, and there may be also relevance to apply that reasoning by analogy to protection against discrimination under investment treaties if between those countries there is investment treaty with non-discrimination clause. May be also relevant in some scenarios apply non-discrimination under EU treaties to the extent to which EU treaties applies to third countries like to Brazil or Japan, free movement of capital, and we will come back to it. And last but not least, or maybe I should start with it, and maybe you know that non-discrimination under tax treaties is an absolute rule. It means that if it's violated, it cannot be justified. By contrast to EU treaties or investment treaties where non-discrimination is not absolute and can be justified. Of course, if justification is valid and proportionate. But here, that's the end of the story. Once it's violated, taxation is considered illegal, incompatible with with tax treaties. For this non-discrimination under EU treaties, I will be very brief because I know that that's not that directly relevant for you, but to the extent to which it is relevant, I want to make a few points. Plus, if there will be more problems with Pillar 2 in Europe, there may be more problems with Pillar 2 in the entire world because European Union is the sole biggest region in which the largest number of countries implemented Pillar 2, 27. And we will look at it also in a bit, why it is important. So non-discrimination, as reflected in Article 18, there's prohibition of any discrimination on grounds of nationality, which also includes tax residence. Nationality for companies is the residence of companies. It's also reflected in the EU Charter of Fundamental Rights. And Court of Justice applies very broad, I would say, interpretation of what is precluded under non-discrimination provision. It is typically in conjunction with the restrictive effect of domestic rules on fundamental freedoms, like domestic rules, Pillar 2 domestic rules. I share with you citation with one of the most recent cases decided, it is a Dodge case in front of the Court of Justice, decided early October 24. I published quite a lot about it, and they will both in blogs, but you will find soon in-depth and a comprehensive article of mine on that topic as well, if you are interested in such case. But the point is that for the Court of Justice, not only the jure overt but and direct, but also the fact that indirect covert discrimination is prohibited. Example, in XBV case, in paragraph 38, I quote, "In particular, a tax regime which provides for a criterion of differentiation that is apparently objective, but that disadvantages in most cases, given its features, companies that have their seat in other member states and which are in a situation comparable to that of companies whose seat is situated in the member state of taxation, constitutes indirect discrimination based on the location of the seat of the companies, which is prohibited under Articles 49, 54 Treaty of the Functioning of the European Union." So the freedom of establishment, which does not apply to third countries like Brazil, but free movement of capital does, and the same standard for non-discrimination applies. But what? Yes.
If I may ask you, consider there is a directive in the EU. Can you, what's the force? I mean, when you have the treaty, the EU treaty, and the directive, which was unanimously approved by all countries, and they accepted the UTPR, would you say that the court would, in any case, say that the EU treaty prevails over the directive or the contrary? Do you have cases on this?
Yes, that's here. That's this slide, Luis. I will address your question here, and let me know in the end if that's satisfactory. So that's a big difference between every and each EU member state applying Pillar 2 rules by contrast to non-EU member state, because in EU, the implementation of Pillar 2 took place through a kind of multilateral treaty, which is directive, unanimously decided, negotiated, and decided, adopted by member state. So even though, so I now make this conclusion very fast. It's relatively clear that UTPR will lead to de facto and indirect covert discrimination because it differentiates between different scenarios, domestic versus cross-border. Domestically, UTPR will never be activated. It will be activated only in cross-border scenarios and only because of the tax residence of the under tax company. If it's not in a state where it's Pillar 2, then it's a problem. But now the question of Luis. Because UTPR and every other Pillar 2 rule was implemented through EU secondary law, the directive, then the Court of Justice may decide that, and now first question, is Pillar 2 directive in EU an exhaustive or not exhaustive harmonization? Many say it's exhaustive. If it's exhaustive and the court will agree, then the court will never examine the compatibility of domestic UTPR, let's say, with the EU primary law. It will do so only in respect of the directive. So the court will check whether the EU Pillar 2 directive is incompatible with or compatible with non-discrimination principle. And here the standard to say that directive is incompatible, it's much higher. The threshold is the so-called manifest error, very high. It was found by court only very few cases, like in the relatively recent case regarding the legal privilege of attorneys and tax advisors, the directive requiring from them to violate the legal privilege law was in violation. It was like manifest error. But whether it will happen in respect of Pillar 2, we don't know. But even if the court would say no, there is no exhaustive there is no exhaustive harmonization, and will examine the compatibility of the domestic law, not with directive, but directly with the primary law, with the treaties, then still high standard will be applicable, because the court will not lose from in front of his eyes the view that it was still directive that was the base for the EU member states to implement the law, and the Court of Justice typically gives quite a lot of leeway, a lot of discretion to EU legislator. We can see it after ATAD, Anti-Tax Avoidance Directive. And finally, only one fundamental freedom is relevant in relation to third countries, which is the one in Article 63 of the Treaty on the Functioning of the EU, free movement of capital. And this freedom applies only if domestic legislation does not target the purpose of the legislation is decisive. If the purpose of the legislation is not to target only definite influence cases. And the question, is the UTPR purpose to apply also to constituent entities over which there is no definite influence in the chain of entities? I would say perhaps yes, but many say, well, Pillar 2 by design, because it applies only to groups that consolidate profits, the purpose of the legislation is to apply only to definite influence. So again, will court look at the entirety of Pillar 2 rules or the specific purpose of the element of the legislation, which is UTPR? We don't know. But I think it will be easy way for the Court of Justice to not bother and simply say there is only definite influence, and therefore free movement of capital does not apply. That will be way out. But let's say the Court of Justice decided that free movement of capital applies, and therefore Brazilian entities are also protected. And also court will find that there is, of course, discrimination at earlier stage. Now the question, can UTPR be justified? Well, if we reach that stage, which is in my view unlikely, but if, then we may deal with, in that case, with three valid justification. Prevention of tax avoidance is justified? No, because UTPR applies irrespective of any abusive tax avoidance factors like wholly artificial tax avoidance purpose, etc. Second justification, the need to ensure a cohesion of tax system can be justified? No, because taxation under UTPR is by any connection and any condition on receiving a tax benefit from another state, whereas it must be present for that justification to apply cohesion of tax system. And finally, the need to preserve of the balanced allocation of taxing rights can be justified? No, with capital letters, because UTPR actually violates the balanced allocation of taxing rights as agreed under tax treaties, because it is contrary to Article 7, paragraph 1. Of course, if you say that it is not contrary to Article 7, paragraph 1, and the way how income is allocated by states under UTPR is perfectly and it follows from tax treaties, then I'm wrong here. But yeah, we can discuss that later as well if you disagree here. What are then the purposes of the UTPR that may match some other justifications, or why they do not match the valid justification? So the four goals of UTPR I identified is increasing revenue of states, ensuring level playing field and fair taxation, whatever it means and whoever decides. Until today, no one decides very well. Fight against aggressive tax planning, and ensure that tax on profits is taxed, of M&Es is taxed somewhere to a certain extent. But there is also an idea that stems from an opinion of the Advocate General Juliane Kokot, according to which UTPR might be, she didn't say it, but it's like by analogy to her reasoning, that UTPR might be justified under a new argument, not tested yet by the Court of Justice, which would be the need to ensure minimum level of taxation. I said it's doubtful, because this argument is directly contrary to the spirit of the European Union treaties and the single market. The Court of Justice, since Cadbury-Schweppes, was very vocal that the fact that in some member states taxation is lower than another does not mean that another state is entitled to tax under tax profit, and this is about UTPR. It's unheard of that that the Court of Justice would simply forgot or decide against his bedrock solid case law. So, but as I said, to reach that level is unlikely. I think that the court would not bother to examine compatibility of the in the free movement of capital scenario. Now let's look a bit about tax treaties. And again, although I am very passionate about tax treaties, investment treaties, also tax treaties, I did my homework and I checked entire database of tax treaties concluded by Brazil. Imagine, it looks like I have nothing to do in my life. No, I'm joking. This database is very little. Of course, you know, or you may have known that Brazil is not fan of investment treaties. You can try guess how many investment treaties has Brazil in force? Only 3. I forgot I put the answer here. Sorry. So it's with United Arab Emirates in 2019, Mexico and Angola 2015. And even if those treaties contain an explicit non-discrimination rule, which is national treatment, they call it national treatment, and also you can find or you can interpret non-discrimination for fair and equitable treatment clause in those treaties, it is of little to zero use. Why? Because those treaties, first of all, do not allow investors to arbitrate against states. And without that, investors do not have the most powerful enforcement tool to actually get protection. So here I could stop and say, let's skip it, but let's go a bit further. Moreover, those investment treaties of Brazil include comprehensive tax carve-outs. And this is example from Article 11, Brazil, United Arab Emirates bilateral investment treaty. It basically says that nothing in this agreement shall apply to tax measures. We shall not be applied in a manner which would constitute a means of arbitrary or unjustifiable discrimination or a disguised restriction on investors. And it continues. But then in paragraph 2, subparagraph B, it reads as follows. For greater certainty, nothing in this agreement shall be construed so as to avoid the adoption or enforcement of any measure aimed at ensuring the equitable or effective imposition or collection of taxes. And the question, what if imposition of taxes is not equitable? Right? If you prove that the way how UTPR operates is not equitable, but still Brazilian investment treaties do not have arbitration clauses that allow initiate arbitration by investors, but they are still of relevance, not Brazilian investment treaties, but investment treaties in general. Why? That's something new. I was quite excited when I came to that discovery. Investment treaties, even for Brazilian MNEs, are relevant because of the concept of shareholders' reflective losses, SRL. I'll explain it briefly to you. This concept allows not Brazilian MNEs, but investors, non-Brazilian investors in Brazilian MNEs to arbitrate against states, wherever taxation under Pillar 2 reduces their returns from investments in Brazilian MNEs. For example, because of that taxation under Pillar 2, they receive zero or lower dividends or lower capital gains, and they can quantitatively prove it. Counterfactual situation, before and after implementation of Pillar 2. And by doing it, very powerful, because by doing so, they can challenge not only UTPR, but all rules, QDMTT, IRR, and UTPR, and a real life scenario. Consider that there is a Swiss investor or US investor, but let's focus on Swiss now. In the Brazilian MNEs, it has shares in the Polish subsidiary of the Brazilian MNE. and this Polish subsidiary is subject to global minimum taxation there. Let's say QDMTT. You look at the investment treaty between Switzerland and Poland. Why? Because you look always at the investment treaty between the home state of the investor, in Zurich in that case, and the host country of the investment, which is Poland in that case, right? Here you don't have a comprehensive tax carve-out. You have arbitration clause, and you have clause according to which Poland shall not impair by discriminatory measures investment. And also Poland shall ensure fair and equitable treatment. So if you prove that the Polish Pillar 2 rule is discriminatory or unfair or unequitable, then this provides protection to the Swiss investor. If you look at the case law investment treaty tribunals, you will find that similarly to Court of Justice or even more, they follow broad interpretation of non-discrimination provisions under investment treaties. Namely, de jure and de facto discrimination are both direct and indirect discrimination precluded. What matters, tribunal stated at Occidental versus Ecuador case in Award from July 2004, what mattered is the result of the policy enacted and the interpretation followed by the contract, in fact, has been a less favorable treatment. So if in fact there is a less favorable treatment of the domestic, of the foreign investor versus domestic investor, the clause is activated. The same follows to some extent from the fair and equitable treatment core element, which is non-discrimination, like in Rumeli versus Kazakhstan case. But here the threshold is typically higher to prove non-discrimination because it typically applies together with bad faith or arbitrary elements. So if it's only discriminatory but not in bad faith or not arbitrary, it would be more difficult to prove. However, it is relatively clear that UTPR will be captured by non-discrimination provisions under investment treaties. In some cases, even by non-expropriation provisions, if UTPR applies to loss-making entities, or in any case where there is profit-making entity, but still an entity has no enough profit to pay UTPR because the taxation is higher. What could be argument then of UTPR, since this is under tax profit rule? Well, the tax should be paid somewhere under Pillar 2 until exhaustion, until 15% effective taxation is reached at the level of MNE. Well, that argument will be easily dismissed by the investment treaty tribunal, as for example, per paragraph 1588 in Carn versus India case, in which the tribunal observed, as for the Carn, a company investor from the UK, paid no capital gains tax anywhere in the world, line of argument. This is, in the tribunal's view, really goes to matters of tax policy, not law, which are matters for legislators, not for the tribunal. The tribunal must decide on the basis of the law, irrespective of what its members' views may be as to the overall fairness of the transaction from a policy perspective. So if you go beyond the Brazilian network of investment treaties, then you will find that both for QDMTT, IRR, and even, of course, also for UTPR, investment treaties may be relevant. I have no time to explain to you how important it is to understand the power of investor-state dispute settlement, how much more powerful this tool is for investors by contrast to domestic litigation or a non-investment treaty arbitration, but this slide explains that. We can do it on another occasion. And I am conscious of time, Gustavo. Please let me know how much more time I have, if I have any time left still.
We still have 15 minutes.
Okay.
So
Okay.
you can go a little bit more, and we can try to open for questions if there's time.
Okay, so let me be relatively quick on customary international law. So here we deal with the nexus and under tax profit rule again. So customary international law is is problematic for us tax lawyers because we either never or very rarely hear about it in our lives. But it becomes more and more relevant because of the digitalization, digital service taxes, and exactly because of Pillar 2. Why? Because the typical nexus and distinction between source and resident taxation becomes obsolete and blurred. Nevertheless, customary international law, even if requires a little, still requires something from states. It requires to tax income in accordance to nexus, or to identify genuine link, nexus between their territory and either tax subject, taxpayer, which lead us to worldwide taxation, resident taxation, or taxable object, income, source of income, which is about source taxation, right? And the question is whether UTPR, but also DSTs, comply with that nexus or not, whether taxation comply with that nexus or not. Clearly, both rules, UTPR and DST, taxation under both DSTs and the UTPR, are a part of the current reconsideration of nexus, which emerged from the brick and mortar economy, and now we have digital economy. So there is a big erosion of the meaning for permanent establishment under tax treaties, but there is not enough agreement between states to implement multilateral treaty that will change the threshold for permanent establishment, to lower it down and capture also existence by means of providing digital services without physical existence. So in that regard, in regard of nexus, UTPR creates very serious tension, because, so again, there are two schools of thoughts. One will tell you that this is all fine with nexus because UTPR taxes resident income, resident entity in respect of its income. So there are no limits even under tax treaties. But think about it a bit. Is it really so? Again, if you apply general principles of law, if you apply a principle of good faith, substance over form, and proportionality, who is actually, or where is actually the source of the income? In the UTPR country, or in the country of the undertaxed entity? The latter is obvious. There is economic substance responsible for creation the income. So if you want to tax income when the value is created, you definitely not do it by UTPR in the UTPR state. It's contrary to that. But that's what happens. But even if you don't believe that customary international law does require from states nexus for purposes of income taxation, then you can look at the pervasive state tax treaty practice, which is one of the evidence of creation of custom. You can look, namely, at Article 7, Paragraph 1 and the wording there, that the profits of enterprise can be taxable only where the enterprise has residence, unless there is PE. And of course, there is no PE, and yet there is taxation. So I think there is problem. Quickly about treaty dodging. So Pillar 2 rules, again, by means of the interconnection QDMTT IRR connection and QDMTT UTPR connection and IRR UTPR connection, is problematic for tax treaties, because the question is whether taxation under UTPR regards object which is in scope of treaties, namely income tax or substantially similar taxes. I would say that UTPR is at least tax on elements of income or tax substantially similar to income tax. It is inexorably linked to income, another entity than domestic one, which is contrary to nexus, but nevertheless the income. If not income, there is no taxation. Income is the clear measurement, and you cannot really forget about it. But of course, UTPR has different name and it's not typical income tax. So you may say that countries deliberately designed UTPR in a way that will dodge their obligations, circumvent the obligation under the treaties. And there is very good book about the improper application of tax treaties by Vanessa Ruda Ferreira, a fellow Brazilian, very nice person and very good scholar. And by the way, her supervisor, Professor Stefan Wegel, wrote his PhD and defended in 1988, entitled "Improper Use of Tax Treaties" and by taxpayers, so about abuse of tax treaties by taxpayers. And she wrote about abuse of tax treaties by states. And UTPR is a good example of it. Why? Because you may say that design and implementation of UTPR stems from the action of a contracting state after conclusion of the treaty. And at the time of conclusion of the treaty, it was unheard of that something like UTPR will emerge, and even if that it will escape this close substantially similar tax. So it is, you may say, treaty dodging, because UTPR stems from a deliberate design to escape obligation of states under Articles 7 and 1 and 9 of tax treaties. And in respect of the Brazil-Japan tax treaty also, Article 24, which is non-discrimination because it applies only to income taxes. One of the last slides, this is so far the only challenge in front of the courts of the Pillar 2, namely UTPR in Belgium. You have 4 arguments why it's challenged. Who challenged? American Free Enterprise Chamber of Commerce, non-profit organization. You would not believe it, but yes, that's what happens. There is no really directly affected taxpayer, but a non-profit organization which represents the interest of many US MNEs. So arguments: violation of right to property because of disproportionate taxation. We already spoke about it during the first part of my presentation when I discussed proportionality as one of the general principles of law. Secondly, violation of freedom of doing business and legal certainty. Third, violation of non-discrimination. Here they focus on the lack of distinctive different treatment between loss-making and profit-making companies. And finally, a relation to what I just shared with you before, nexus, which is the lack of sufficient nexus with Belgium, and therefore the violation of principle of territoriality in taxation, which stems from customary international law. And for each argument, in addition to questions asked to Constitutional Court in Belgium, there were requests for preliminary ruling to the Court of Justice. Of course, not requests made by the Constitutional Court, and only Constitutional Court can do it, but they suggested to the court. And why there was so big pressure to do that? Well, because if the Court of Justice decides that UTPR is incompatible with EU treaties, all those 4 arguments considering, then UTPR may collapse not only in EU but globally. Way it may happen, well, if the Belgian Constitutional Court does not decide to ask ECJ, then we will have judgment by mid-2026 approximately. But if it does, and we all hope that it will do so, then it will be mid-2028. And why it may be collapse of UTPR not only in EU but in the entire world. Look, this is the map of Pillar 2 legislation, either in force or draft. It was valid, it was up to date by late September, and this map stems directly from the OECD website. Look what happens if I take out UTPR in Europe. How many countries you will have? 3 in Africa, 1 in North America, 2 in Latin America, and 7 in Asia and Pacific. So then bear in mind that the less countries have UTPR, but if some have, then the destructive power of UTPR in those countries being extremely disproportionate and expropriatory will be bigger. So it makes sense for countries to have UTPR if many of them have. Therefore, one of the arguments of Professor Breitzu is so relevant, because UTPR has no coercive power at all. Or if it has, it is blatantly in violation of international law. So how it can survive? And we should not wait for litigation to get rid of it. countries are responsible to do it earlier. I will back to it. So risk of violation of international law by Pillar 2 is not negligible. It's significant. And it's important for strategic tax advice to factor in different sources of international law, not only tax treaties with Pillar 2. And clearly, UTPR is most vulnerable to be challenged under international law. And states, the OECD, EU, G20 really did not seem to put much attention about compatibility of Pillar 2 with international law while designing those rules, especially UTPR. And as I said also before, really states should not wait for litigation to redesign or just repeal UTPR. They should do it now and or not implement it at all. At least wait and see is a good strategy. Bonus, and I will not discuss it. I know that Professor Aviona discussed it a bit, and maybe Professor Browner will. We are now observing carefully the US administration and their defense rules activation of section 891 maybe, and prospective section 899. I conduct research on that topic and verify whether the US countermeasures are legal under international law, but this is the work in progress. So yeah, I'm happy that I was still on time. I pass voice to you.
Thank you, Blazes. I do have a couple of questions, but we're short on time. Let's see if somebody here or somebody online does. And yes, go.
Hi, Professor Blazek. Thank you so much for your presentation. And as regards the non-discrimination article 24.5, when two countries negotiate the tax treaty, they provide for rates in the article of interest, royalties, and also dividends. For instance, 15% a cap rate. So a country, the source country, cannot tax above this threshold. But when you apply a tax like the UTPR, in the end of the day, you are circumventing, in my view, this provision because you are applying a tax under a company that in the end of the day, you could tax a major rate, I mean 25 rates for dividends, but you are circumventing this provision by taxing the company for a tax or a taxation in a taxation that is not the same for the other companies that's resident in this country. So I think that this reinforce the fact that the UTPR may violate the Article 24.5 because you have this surtax that was not accorded with the other country that negotiates the tax treaty with this country that is applying the UTPR. I don't know your views about this.
Yeah. So it was more statement than a question. I had similar discussion with my colleague from PwC Netherlands, but he referred to Article 7. The fascinating thing about UTPR is, and I here agree with you absolutely, that we discussed non-discrimination, but you stood up and say there is also a problem with that. Yes, I agree. The magnitude of circumvention, but by that rule, tax treaty is really big. It's really wide. You can argue like you, of course, depending on the situation. If you have a situation of domestic, if you have a situation of dividend taxation and you have cap of 15 or 10 or 5 or 0, and here you have no limit, entire fabric of tax treaty is torn apart by UTPR.
So, Blazes, I have a follow-up on that one. Do you think, in your opinion, 24.5 would also prevent the application of QDMTT in case of a host country that has a treaty with the other country that does cover all taxes, so that doesn't have the problem that you mentioned on the Brazil-Holland treaty? Do you think it would apply to QDMTT? And if yes, I have a follow-up on that one, but I want to first hear your opinion.
Yeah, I got that question from Professor Veitzur before, and my quick answer is no, because QDMTT can be defended by comparison to the general corporate income tax system, right? It's very similar simply by expanding taxable base or by increasing tax rate. So you either horizontally or vertically change domestic corporate income tax system. And you will question me, well, but QDMTT is also activated when there is Pillar 2, and Pillar 2 is about multinational groups, even though Pillar 2 applies only domestically, like in EU, to avoid non-discrimination question. But there are many countries in which corporate income tax is suffered mainly by companies owned or controlled by foreign companies. That doesn't mean that entire corporate income tax system is discriminatory, right? The smaller the country, the more exposure to this type of reasoning. Yeah, so that will be my answer. In theory, yes, you can consider that. In practice, it's extremely unlikely that you will be successful.
All right, great. I see that Professor Browner has joined us. Just one last quick question. Do you think you said about the bilateral investment treaties that the SRL could apply, and that is a very interesting point. Another one, as you mentioned, Brazil doesn't have investment treaties that are relevant because the treaties that are enforced don't have investor country arbitration. But do you, what is your experience with that? We don't have that much experience with this. So could bid shopping be a thing? I mean, to set up a subsidiary in a country that has a bilateral investment treaty with your target country, and then invest to the target from there, and then to claim bid coverage by having a subsidiary in that intermediate country. Is that has that been analyzed or not?
Well, of course, investment treaty shopping is similar to tax treaty shopping, but here you have two problems. One more obvious and less, and one less obvious and one typical to Brazil. So, if you set up an entity solely or predominantly to get access to the treaty protection, and you do it when you could reasonably anticipate that there will be dispute that you will initiate, it's abuse of process. And it stems from the Philip Morris line of case law against Argentina, in which there was no investment treaty with Australia, and it was meant to protect investment in Australia. So they set up subsidiary in Hong Kong, and there was treaty between Hong Kong and Australia. And the conclusion was, we do not have jurisdiction to decide the case because it's abuse of process. And by the way, it was so damaging for the reputation of that investment treaties that Australia decides to terminate it. And for the second answer to your question, if you want to strategically think about reorganization of the group to enter into protection, you can do it, of course, and I can help you to find arguments that it's not abuse, but you will never be able to do it in respect of countries like Brazil and South Africa, in respect of investments there, because those countries have no treaties.
Sure.
That's simply as that, you know, and because of that, no matter what you do, you end up with being not protected in Brazil in respect of investment treaty arbitration. You can deal with that only in front of Brazilian courts. But you can use the argumentation from analogy to investment treaty protection in front of Brazilian courts, because this protection has usually constitutional status.
Mm-hmm. All right. Professor Blazes, thank you very much. It was great. There's a lot of stuff that we have been thinking about regarding the MTT and the legality of it, the treaty status of it, and this has certainly provided a lot of food for our thoughts. Thank you very much for your participation.
Thank you so much. Thank you so much. Bye.
Thank you, Blazes. You're always welcome in Brazil.
All right, Professor Yariv.
Yeah.
Hello, how are you?
How are you?
So nice to see
Fine.
you.
Very good too.
Shweti, there you go. So Shweti is online. I'm here with the students. I think you have a kind of a view of them. And we just discussed with Blazej legality under constitutional law, treaty law, investment treaty law. And now let's go to the U.S. and discuss particular American rules and how they relate to the Pillar Two rules. And hope you can give us an overview. And of course, everybody, we spoke a little bit to Ruven about this, but of course, we want to pick up your brain on that, on how do you think this will play out in the US and on the long run. So, Professor Browner, I think everybody here knows you, but for those who don't, he's a professor of the University of Florida in Gainesville, a great friend of ours, very enthusiastic in internationalizing and participating in Brazilian congresses. So it's a pleasure to have you here. Professor Browner really bridges the gap between European line of thought, American line of thought, and the developed and developing world reasoning. So it's amazing to have you with us. Thank you very much for accepting our invitation. And please, the floor is yours. We want to hear as much as we can.
Yeah, thank you. So I prepared a kind of a presentation.
You can share your screen or your window.
Yeah. See, does it work?
It's not on presentation mode yet, but it works.
Yeah, let's see.
There you go.
All right. So, hi everybody. It's always a pleasure to speak to you and of course to see you, old friends now. I was invited to speak about Pillar Two in the United States in a very, very generally, let's say. And in some ways, the title here is most fitting, what there is to say. So I will, at least the presentation will be about this. And if later, of course, we want to discuss other things, more generally about Pillar Two, I'm happy to do that. So, from a U.S. perspective, I wanted to go a little bit to the political setting and the history, and then see a few provisions in the United States. Some of you, I'm sure, are a little bit familiar with them, and some of you may be a little less familiar with them. They might be useful for a full understanding of the situation. So, a really brief, what I would think is historically relevant. So, as you all know, the BEPS project started with the United States being an enthusiastic leader of the project. And then very quickly, it changed its stance to start playing defense. The United States didn't win any argument really that it tried to promote positively. The only wins were in reducing the impact, particularly the impact on US multinational corporations. The Biden administration came in and really started to be, very active within the OECD. And the OECD is a funny organization. Sometimes, they pretend to be this leader of international taxation, but from time to time we see different countries having more power than others in that organization. And interestingly, during the Biden administration, after many years where almost everybody in the top was French, now we have a lot of Americans there, which is also a little bit ironic. But the Biden administration was pushing the agenda of BEPS 2.0 or Pillar 2. At the same time, that there was absolutely no chance domestically of adopting these provisions. So this is, I think, a critical point to understand when we're saying, what is the position of the United States? What does that really mean? That the fact that the president says something about the position of the United States, is that the position of the United States? No, not necessarily. And I think this is probably the most perfect example, because President Biden and his administration didn't even have the votes of their own party, even at the time where that party was the majority at Congress. Eventually, what they did do was pass a piece of legislation that had a tax element, and I'm going to go into it in a little bit, but the most relevant for us, there were some tax expenditures, some especially energy-related, green energy-related credits, and with it, an alternative, a corporate alternative minimum tax that looks very much like the globe, but it is not the globe. In the meantime, as you all know, probably you discussed, the EU proceeded, and some other OECD countries proceeded with the adoption of Pillar 2. Even before the elections, we saw the Republican leaders of the House, but you have to realize this is not just a political standing, this is wider opposition to Pillar 2 and to DSTs. There were threats of retaliation. A specific letter was sent to the OECD, to leaders of the European Union, to Canada, with respect to a DST that Canada just very recently adopted, with direct threats of retaliation. Now we have the election. President Trump comes very forcefully into power. We've all heard all sorts of things in the news. And part of the agenda was a direct or explicit statement that the United States withdraws from the so-called inclusive framework at the OECD. So this is the political setting for this. The globe is an interesting, or Pillar 2 is an interesting provision. It has an element of anti-deferral. It has an element of really a global minimum tax as declared, and it has an element of a compromise for the preservation of the power of the OECD in a world where the rest of the countries of the world come and say, well, we really don't like the deal that you are promoting. So it has different facets. But from a US perspective, we've had anti-deferral rules now for a long time, from really early in our income tax. This is just kind of an example. Some of you studied US tax. You know the mess that these rules have caused. Eventually, in 2004, we had legislation that eliminated that, and now, at least from 2004 until 2017, we had two general relevant regimes. One is Subpart F. It's our CFC legislation. It's let's say a medium CFC legislation. It's different from other countries, but it's not based on the rates directly, but it does have a rate limit, specifically an exemption, essentially for what we call high-taxed income. In the United States, the current nominal rate, the corporate tax is 21%, and the law says that any effective tax over 18.9 or 90% of the nominal tax rate will be considered a high tax, and therefore it will not be included under the CFC legislation. Another thing to say about it is that the active income part of this had been very weak for quite some time in the United States. Multinationals feel pretty comfortable with it and with deferral more generally. And the result of it is that US multinationals suffer relatively low effective tax rate on their foreign source income, even after the dramatic reduction of the rate in 2017 from 34% to 21%. So now we're kind of middle in the middle of the map in terms of the nominal corporate tax rate. In addition, we have some accounting rules that support the ability to defer income, which are really critical, of course, for US multinationals that are among the largest multinationals. I think it's safe to say that the US still has the majority of the largest multinationals headquarters and really primarily located in the United States. In 2017, we have an enactment, almost surprising enactment of provisions that had mixed, and you can look at it in two ways: mixed because mixed policy purposes. It's mixed because one could say cynically, it's mixed because they didn't know what they really wanted to do, and or mixed because it went in different directions. Most famously is the GILTI legislation that effectively made the United States a worldwide taxing system at the time that the rhetoric was a rhetoric of a switch to a territorial tax system, right? GILTI piggybacks on Subpart F. Basically, it says if you earn income through a foreign subsidiary and that income is not subject to the CFC legislation, the Subpart F legislation, it will be subject to GILTI. Now, part of that income is exempt from GILTI, but in general, it's subject to the GILTI regime. So again, income that is deferred through the foreign source income of subsidiaries of US multinationals is generally taxed in the United States with specific exceptions. At the same time, the US also adopted a participation exemption regime for dividends, right? So if you take away the dividend, or if you view the dividends as primarily secondary income to the original, let's say, business income earned by the subsidiaries, then what we really have is a worldwide tax regime without deferral, with some exceptions. The exceptions are formulary, and this is how GILTI works. It's formulary because the regime basically says, let's look at your foreign assets, not all your foreign assets, essentially are tangible business assets, and we will presume that they make 10% profits, a yield of 10%, and we're going to exempt that amount. Currently, it's based on the accounting, actually, so on the adjusted base, the tax accounting base of these assets. In addition, the GILTI portion, so not the Subpart F portion, the Subpart F portion or the CFC legislation portion is a net-based regime, really anti-deferral regime. But the GILTI regime presents a much more complex set of rules because the rates are different. And the way it was done is through the grant of particular deductions. One deduction is kind of automatic, almost automatic. This is half of the GILTI, which means that GILTI will be more or less at half of the rate. And in addition, there is a special deduction, quite complex, given to what we call FIDI, or income derived from sales of services to foreign unrelated entities. So this ended up in effective tax rate of about 10 to 13, something like that. If you declare all of the income, if all the income goes through the system. But that was not the end of it, because in addition, the GILTI regime did not give you full foreign tax credit, also not full. It wasn't exactly a net-based regime, and therefore the effective tax rate was quite different, and the tax consequences were quite different from one company to another. So on one hand, you can say, well, corporations had the interest to shift income from subpart F to GILTI because the rate is lower, but that was not always true, and corporations had to really tailor their operations for this purpose, made it much more complex in the running of the numbers. In addition, I want to go just to complete the picture. One other tax that was introduced was an unusual tax in 2017, known as the BEAT. This is a tax that was quite controversial, both from international law perspective, I think also domestically, unclear if it could withstand litigation. But at this point, and throughout these last few years, people thought that the government will repeal it or they will replace it. But anyway, this is currently still the rule. This is a tax on payments, so not on the receiver of the income, but rather on the payer of some payments that the law calls base erosion payment or deductible payments. In particular circumstances, essentially payments of royalties and this kind of payments to related parties. This concerned particularly foreign corporations that thought, oh, the United States now has a low rate. It's a good place to locate our business. Well, the BEAT put them in a more precarious situation. Now, all of these taxes are subject, because of the US budgetary rules, are subject to rate changes over time. The reason is our internal rules, again, budgetary rules, but it will be important for us as we go forward. And if we put all of these together, again, we end up with GILTI as the leader, but together with these other taxes, ending up in a rate that falls, kind of slightly below the 15% that is the benchmark for our entire discussion in the globe context. There were some questions. I assume Reuven discussed this with you about the compatibility or theoretical compatibility of GILTI with the globe. For a long time, people, said it quite directly that the globe was fashioned after GILTI, and there was a discussion whether GILTI will be grandfathered. And now I guess people say, well, maybe it will still be considered a QDMTT, which is a very strange concept, especially the Q. What does it mean, qualified? And who allowed the OECD or anybody else to say that something is qualified or not qualified? But I'm sure you discussed this quite extensively. If we look at it, what we need to realize that the rate is not high enough if you look at it in a serious manner. So there is a space for top up. The exclusion, the formulary exclusion for tangible assets or yield on tangible assets is not clearly, definitely it's not tailored to fit because it predated it. It doesn't fit the exclusions under the model rules that we know today. The computation is obviously different, and there's no qualification, of course. And there are other reasons as well to believe that it will not qualify, at least at this point. Interestingly, at the same time that the United States wishes the guilty to be qualified or grandfathered as, sufficiently close to the global minimum tax, the Biden administration enacts a new corporate alternative minimum tax at 15% and 15% on financial statement income. So it looks very much like what the negotiations at the OECD were focusing on. And to some extent, there was this discussion on whether this is qualified or not, whatever. But the truth was, and again, depend on your political thinking, is that this was just a revenue raiser within a larger legislation that the Biden administration wanted to pass. The original legislation failed. It was called, you see here that the acronym BBB is Build Back Better, was part of the infrastructure bill. But most importantly, the legislation that was called Inflation Reduction Act. US legislation has very weird names. They're political names that have nothing to do with the legislation typically. But in this particular case, what's important, they passed tax cuts, especially for green energy. So there was environmentally sensible tax incentives, and they had to pay for it under our budgetary rules. And because there were all these discussions about the global minimum tax, I assume the government thought this would be a good way of paying for it. And they did what they could in this context while the negotiations at the OECD were going on. Now, we still don't know 100% what this tax will look like, but the key elements are that it's 15% on adjusted financial statement income, again, kind of similar to the globe, but and it calculated a little bit different, but several elements are not the same. We have specific exceptions and some accounting differences that are related to the accounting rules of our domestic laws, especially with respect to the relationship between this tax and Subpart F and indirectly with guilty. There are domestic and international questions that are quite similar to the questions that I'm sure you discussed already with respect to Pillar 2 domestically. Now, again, if we compare it to the globe, we see that we have a different tax base, most likely quite different. The blending is not country by country. The United States abandoned country by country, especially in the context of foreign tax credits in the 80s. And at least for now, even this legislation is not done country by country, like Pillar 2 requires, or the model rule require. There is some different treatment for foreign operations and U.S. Source income. And we also want to ask, well, if GILTI already taxes you at 13%, why do you need a 15% minimum tax? Well, first of all, it's 15%, it's not 13 or whatever other rate it is. It will tax that a portion that is not covered by GILTI, which is that exception for the formulary yield that is attributed to tangible property. And we have different tax credit and taking into account from accounting perspective the credits rule. So a little bit different. The context, as I said, were some energy, clean energy and renewable technology credits. These credits are either direct paid, so which is similar to refundable, essentially credits, or transferable, I think also similar to that, but not exactly like what the OECD, the model rules are. We still have uncertainty about the accounting treatment. And there are, I think, quite serious, actually, valuation issues in these credit. So we ask ourselves then, what's next, right? So the reality is that several countries already have their Pillar 2 rules in effect. They apply the globe, but not all of them apply the globe consistently. We don't have, even to that extent, application of the UTPR. That is the primary, I guess, bone here. But even within the countries that apply it, we have mixed application that is will still have to go through the courts and the interpretation boards and different accounting treatment. There is a question whether the EU application will be harmonized. I'm sure all of my European friends will say, well, they have to be harmonized, but this is a process, right? They have to go to the court, and there will be protests, and there will be litigation. So this is something that will take time. And at the same time, we have also an important safe harbor rule that at least for a couple of years, it is likely that the United States, if this is what we're talking about, will fall into that safe harbor because our nominal rate is above 20%, although that may change. There will be a pending litigation. I heard Blazer talking in the last few minutes, and I'm sure that he mentioned the investment treaty aspects, which will also be, for sure, it will, go forward, at least some of these, and that will put some questions on the implementation of the different rules, but also domestic legislation, basic international law, litigation. So we'll see what's happening. What's clear is that the United States will not join the group. We will not have, definitely not in the next few years, any new globe fitting litigation, unless something really dramatic occurs in the OECD, and it will not be globe. There will be retaliation. We have several options. Again, it's kind of ironic because the person who advanced some of these ideas was the person that eventually is a tax professor that eventually negotiated Pillar 2 for the United States, a big supporter of Pillar 2. But we have various legal routes for that. It's also likely that there will be some litigation, some legislation that will result in stricter application of the rules that will make it difficult for corporations to essentially leave or export activities away from the United States to try and deal with Pillar 2. And there's the question of the political stance of the multinationals, the US multinationals in this context. I think there's no question that there will be litigation on the extraterritoriality. We already heard about the Belgian. I haven't heard in the last month. I don't think anything happened, but if somebody knows, I'll be happy to hear. So US elements, especially industry elements, will for sure litigate that in different contexts. Beyond the QDMTT aspect or the qualification under the QDMTT rules, there's also a question of the compatibility or the relationship between the IIR rules and Subpart F and GILTI, which some countries may, for simplification, choose to accept, maybe through negotiations. As I said before, the safe harbor is currently the United States, but President Trump promised a reduction of the rate to 15%. So it's unclear whether that's going to happen. At the same time, the government or the administration faces an interesting situation because under the existing legislation, a lot of the rules are going to result in increase of the tax rate. So both GILTI rates go up soon. The FDII deduction goes down, which again increases the rate, which is likely that many corporations will fall into the 15% effective tax rate anyway, and therefore there will not be any top up, at least to some, in some cases. We also have a lot of other domestic rates that will go up unless there is some legislation, and we expect some legislation to extend some rate cuts and maybe other elements. Probably the most important from the perspective of the Biden administration, where the tax reduction of the tax credits that were given to under two acts. One are those energy credits that we discussed before, environmental credits, if you will, that we discussed before, and the CHIPS Act. These are incentive to the computer chips industry as part of the trade war, if you will, with China, the protection of Taiwan, all of that. At this point, it is likely that either these benefits already qualify under the model rules, or they could be easily made to be qualified. Again, nobody, I think, I don't know what Woven said, but he likes to reconcile rules, but I'm not sure that's necessarily going to be the position of other countries, especially with the Trump administration applying some retaliatory taxes. So I think nobody knows what will be the end of it, but the reality is that at least the way the current model rules are written, it's not clear if they are going to be. It seems that they could be protected. there's a question of discrimination that came up. I heard again you talking a little bit about that. One element that came in the United States was the question of whether some of our retaliation measures could be used because they're used for countries that discriminate Americans, basically, investor. Remember that, I mean, I find this discourse a little bit weird because people talk about discrimination in very different ways, in very different contexts. And therefore, I don't think it's going to be very difficult for the current administration to simply declare it discriminatory, end off, and, you know, why would we care? And definitely, why would the current administration care how the ECJ interprets tax discrimination? This is a little bit strange to me. So I think this is a minor to a none to a null legal question. Again, some immediate expensing may be threatened supported by the administration, by the way, even though some of it was enacted under bipartisan rules under the former administration. But what is clear is that it's going to be easy for Congress to convert some of the rules, especially R&D expensing, into refundable credit. They already did it in other cases very recently. I don't even see any opposition to that. If that was the problem, there is, maybe Reuven spoke about that, even if not, the way the model rules are written, it is unlikely to be dramatically impactful, especially because of the way the rules use this substance-based income inclusion. So in reality, you could argue that it is not included in the as a credit, but it's also not included in income, and therefore it doesn't impact that much, at least the ETR. And because of that, it will not be relevant for Pillar 2 application. Note also, there are some state taxation issues. The states are now considering what to do. Clearly, the states will have to raise revenue in the future year, and the competition within states is going to be more fiercer, let's say. So these aspects are again unclear at this point, but they may be relevant for those of you who are in practice and they have US locations or US operations. Right, I think. So this is kind of the background for this discussion. So yeah, very little certainty because we're really just in the first days of this administration, but we've all seen that they are not, they're not backing, and in general, I would say they don't have a problem of enacting or taking measures that one would think the courts will easily strike down. They will challenge it. They will let the process go. So whereas in the past, definitely under the former administration, you would say, oh, we're not going to, spend the time and the money of enacting, going forward with things that we believe the courts will strike down. That's not what's going to happen here. They will use the courts, and we will see that, I think, for years now, happening, at least in the United States.
Thank you, Professor Browner. Does anybody here have a question? No, let's see somebody online. I do have a couple. Let's begin with mine if nobody has, and maybe somebody will follow up. The first thing that I wanted to ask you, well, it's two things actually. One, if there are any plans of Trump in repeal the corporate AMT, or is it there to stay? And the second is a foreign QDMTT credible against the guilty and the corporate AMTT, the corporate AMT? That's something that directly worries us because we did adopt a QDMTT. So if a foreign tax credit is allowed against both the guilty and the corporate AMT.
So currently, if you just looked at it, maybe I'll start with the second question. So there's a technical question on the face of it. So if a foreign tax is an income tax in the way that we view the income tax, as you know, it's going to be creditable in the United States. But the US, and in the case of Brazil, is kind of the best example because instead of having one tax, you like to have 50 taxes with different names. Uh, these are all presenting difficulties for credit and uncertainty. So the question is, what precisely your QDMTT will be? Now, if it's going to be 15% only on domestic source income, and the US will accept generally your sourcing rules and the calculation, then there is a chance. The problem is going to be the accounting aspect. But I will not discount the possibility of the IRS coming and saying, well, this is not an income tax. Because it is not on the net profit of the corporation. So think about the US operating in Brazil, and under our rules, it will have X, Y, or Z expenses, and these expenses will be accounted completely differently under your system. There is a risk that no, I'm not saying that it's simply what's going to happen. It looks to me that politics will play a role there. Because the IRS, if it wished, it could come and say, look, if you call it QDMTT, it's going to be not creditable.
Yeah, because those differences are already present in any corporate income tax in the world that you find credible, right? It's never going to be the same tax base as the American corporate tax base.
True, but if we go into the detailed rules, I could make for most QDMTTs, I assume, I could make a good case for creditability. But this does not mean that the government will just say, if you call it a QDMTT, then it's not credible, because you also have, I mean, Brazil actually, it's complex. But let's take the easier case. Let's say, I don't know, Belgium has a corporate income tax, and in addition, it applies a QDMTT. So not replacing the corporate income tax. You open yourself to the argument, well, The QDMTT is not the income tax.
Then the corporate AMT is not income tax, because that's what we're gonna do. We're gonna do it by the same tax, but it's AMT. So
Yeah, so we actually have history. You may know that. Um, this is kind of interesting because historically, completely unrelated to this, as you know, the United States enacted alternative minimum taxes in the past. So we have it for individuals. We had one for corporations. It was disastrous. It was replaced and repealed because it was disastrous. Uh, I think to begin with, it's you know, I'm not a purist, but it's really a bad line of thinking. Because what does an alternative minimum tax say? It says that the system is broken and we're unable to fix it. So what we're going to do, we're going to have a parallel system. That's what it really does. So historically, we had some issues with certain taxes. Remember, the United States provide foreign tax credit unilaterally, right? So it's not subject to treaties, and therefore the Brazilian taxes have actually they were the stars of the show. Any U.S. Class on foreign tax credit uses many Brazilian examples because they were in the past the star of the different conflicts with these rules, right? So, but there were particular taxes that were rejected for credits. So even if their economic impact was similar to an income tax credit, for a variety of reasons, they were rejected. But historically, in most of these cases, these were taxes in countries that were, relatively poor countries or small countries without, with significant U.S. investment. All right. But then in the 90s, Italy adopts a tax named the IRAP, which was an alternative minimum tax, very similar to the US alternative minimum tax. And Italy is a kind of a close friend, OECD country, etc. And that raises quite an issue. And in the beginning, what the US did is they said, well, we're not sure because people wanted the rulings about the IRAP. Is it creditable or not creditable? Because again, it was not, there could be arguments for both sides. And then in the beginning, what they said, okay, we're going to grandfather it, but we're not ruling. The same thing, by the way, happened with Mexico. Again, a close ally, a neighboring country, OECD member, etc. In Mexico, it was eventually resolved because the Mexican Supreme Court ruled it unconstitutional. But in Italy, eventually they gave the credits, but they didn't say that, this is kind of a precedent. You can do the same thing. So I think you already have a basis for rejection of this type of taxes, despite the fact that the US does the same thing. Now, with respect to withholding taxes, it did not happen, right? But with respect to withholding taxes, we have a provision in the code, as you know, that says that you could get a credit in this in particular case for taxes in lieu of an income tax. Now, the QDMTT is not in lieu of an income tax in most of these situations. Again, in Brazil, I think it's going to be a little bit more complex because you have a few taxes. So, and of course, we don't have a treaty. Although most people believe that the treaty is irrelevant for this purpose. I'm not so sure, but this is another discussion.
But the Brazilian administration choose change the net profit social contribution, so it's additional of our income tax. So I'm not sure if we are saying that we have the social contribution that already exists, and it's just another phase of and you sum the top up tax in the same
Yeah,
income
it
filing.
works. It
So,
works
but no,
like
but
him.
the contamination could reach all the
You might think the whole thing.
no,
Yeah,
the whole thing,
yeah.
because like
No,
it's not based on
It's an
that.
AMT. Her point is that it's written as an AMT, but it might taint the whole payment because it's a top up tax. So if I paid, I don't know, 8, and there's a top
Yeah,
up of 2, she's saying that it might taint the whole 10, or will they stick to the 2?
that
Yeah,
I
no,
don't
no,
think.
tainting. I don't think they would taint. I think that what you would claim, but correctly, is the opposite. Say, well, since the states already credit the 8, they would credit the 10 because it's the same tax. And it's not true. It's the same name of the tax, but it's not the same tax. It's a different basis. It's a different taxpayer. So to say that, because yeah, if I to know, our top-up tax is called an additional to the existing tax, but it's an additional with different basis.
Yeah,
Additional that only some taxpayers pay. Additional based on it's at the top of the tax. It's a QDMT.
Mm, yeah.
So the fact
so
that you
so
call it a different name doesn't mean that I mean that name is not
but
relevant here.
yeah, so I mean, maybe two things to mention in this context. Um, so one historical issue that we had with foreign tax credits directly was the case of the advanced corporate tax in the UK, right? So in the UK, I forgot the era, but I assume it's the 70s, 80s. Um, uh, there was what's called an advanced corporate tax. Advanced corporate tax was an addition to the corporate tax that was paid on behalf of shareholders in lieu of the dividend tax, but it was a tax imposed only on corporations. All right. So instead of, let's say, 5% dividend tax, they added to the regular corporate tax another percentage point, and it was paid by the corporation, and then the shareholder, the the UK shareholder, got a credit for this particular advanced corporate tax. A US person that invested in a UK corporation argued that this tax is really in lieu of a tax on dividend, and therefore he wanted the credit for that, and it was rejected. Right? Now, the background here was that you were not the same taxpayer, but again, we see the formality of this as very important. We had the same thing in Germany, right? Remember, there was this surcharge or surtax after the fall of the Berlin Wall. What is it called? I forgot the name. The unification surcharge or the unification surtax in Germany.
It was called solidarity.
So that solidarity, exactly. So all of these are good examples, I think, and none of them gives us confidence. In fact, now remember, in the US, you can go to court and you can argue that, and I think you have the technical argument in these cases, but another example, I'm sure some of you heard, when Norway decided to, when Norway discovered oil, they decided instead of increasing the rate of tax on the oil income, they said they're going to use the same rate, but it will be calculated based on 120% of the base. All right, so it's exactly like increasing the rate. And increasing the rate is fine, no problem. But the entire thing was rejected as creditable. So from a US perspective, the creditability is kind of an internal issue. It's not a matter of relationship with the other countries. We give the credit because we think it's good. And if we think it's not good, we're not going to give you the credit. That's the perspective. And because of that, I think it's unclear. Gustavo, you're muted.
I think Blazej wanted to ask a question.
If I may, thank you, Yarif. You made the point, or you raised the point that there is zero to almost zero legal question as for the discriminatory identification of discrimination by Trump. I think you referred to Section 891, but maybe also prospective Section 899, doesn't matter. And you refer to ECJ or ICJ, International Court of Justice, or European Court of Justice?
No, I heard a lot of analysis based on the European concept of discrimination. And I said that it's inapplicable.
So that I agree. But there is a specific angle that you can look at it from the perspective of customary international law, which is codified. It's called ARCIVA, Rule Articles on Responsibilities of States for Internationally Wrongful Act. So if US countermeasures, so to speak, you can call them countermeasures, measures, wherever, truly target discriminatory and extraterritorial taxes, but not under EU concept of discrimination, but under international law concept of discrimination, it's enough to say that it's discriminatory under US tax treaties, US investment treaties, or non-discrimination principle as a law. Then US gets justification from international law to do it, providing that that's the case, which is not the case. We both know that they don't care about international law. It's just a pure US approach to identification of discrimination. But let's say they will be more careful, even if they target only discriminatory and extraterritorial taxes, then they are still in the sphere of illegal actions if it's not proportionate. And of course, it's not proportionate. I mean, Section 891 may reach 80% of a Polish citizen living in US 20 years, as long as that guy or girl doesn't have US citizenship, will be captured by means of the taxation of US corporation under Polish UTPR. There is no equivalence whatsoever, and the proposed measures by the Congress will be activated even though there is no actual taxation, because they say that adoption of UTPR or DSTs are enough. So I think that there may be some nasty litigation in the future if Trump's administration will put that forward. I don't know which court would be relevant, either US courts or second opinion International Court of Justice, but I agree with you that ECJ is of minor importance here, and the perception of discrimination, I mean, maybe used as a kind of source of interpretation, but
so couple of things. I think you're right in this context, but the interesting thing about politicians is that the legal advice that they get is, only part of it goes through.
Mhm.
And for example, they could pass it not because of discriminatory treatment, but because of harmful treatment. And then you run into different issues. I think the more serious, of course, challenges will be under investment agreement. I think that's also the most fertile ground for challenges also of the UTPR. But you may have domestic um, uh, uh, challenges of extraterritoriality. And remember, when you do it domestically in the US court, especially in the current environment, um, you have the normal home bias, which is true in many places. A You have the disproportionate impact on US multinationals, and that may happen in times of economic crisis. So we may face an economic crisis very soon, a depression, even global depression, very, very soon. And you may face litigation that is very long, you know. So, and in the meantime, who knows what's going to happen. And on top of that, you will then have to actually affirm the award with the courts. And another aspect that's really important, in most of this, you will have opportunities for retaliation in the United States. Whereas, with all due respect, some countries may want to retaliate, but they don't have asset to retaliate against. And to some extent, this is a power. Whether it's good or bad for the United States, I think this whole thing is really bad for the United States. But the opportunity exists here. And remember also that the government does not have to use current legislation. It can enact new legislation for this purpose. And it may even decide to apply, um, executive power based on, wartime style executive power orders. So this is very dangerous and really not good for anybody, I view. Definitely not for the United States, but at this point, I wouldn't say that it's simple that they will not do that.
Mhm.
Any more question? Just a follow up on the last one. So we have possible non-credibility of the QDMTT. We have possible issues with the push down of duty in the corporate AMT for calculation of QD entities all over the world and possibly UTPRs. Uh, isn't is it something that worries U.S. policy that you might not be a very interesting place for UPEs if Pillar 2 sticks at least a little bit? And you have a shift in UP home to other countries, because one thing is you don't have you are fully territorial, you don't want to have an IR. The other thing, I have this whole bunch of weird rules like corporate AMT, like guilty and so on and so forth. And guilty, the guilty has the issue of driving activity outside of the US that I'll not get into it. But you have this whole set of rules, and you say, no, I'm not gonna change it to adopt an IRR, which will be credible against QDMTT and so on and so forth, and I'll keep this system. Is that a way to go if you want to still be an attractive country as a home country? You don't care about that. You don't care about inversions anymore. So how does that play out?
No, I mean, the US inversions are something that bothers politicians. But remember, most of the inversions, the incentive for inversion already existed. It was even much stronger in past years. Now, at this point, the biggest multinationals have already adapted. They may not like it, but they know what to do. Most inversions do not shift actual economic activity. A lot of the actions in the former Trump administration were kind of mixed. Remember, the guilty was enacted in the Job Creation Act, whereas the incentives there were to put jobs somewhere else. So, we have to realize the cynicism of this situation and this legislation. But is this going to put the United States in a big disadvantage? At this point, it doesn't look like that, and I think there is quite a lot of agreement over that. I don't know what Owen said, but I assume that's what he will say, because I assume that he will think it's even less important than I think it is. Because for most US multinationals, the impact will be kind of minimal. It will be a lot of paperwork, but because they have operations in all of these countries, you have to do it anyway, regardless of where you're going to be. You have to pay accountants and you have to pay lawyers, and you're going to have to do it anyway. So what is the disadvantage? We're not going to attract new corporations from abroad. Well, for the most part, tax is not the main driver in that context. And anyway, good advice from a tax perspective would have been to not have the UPE, if you will, in the United States. So again, regardless of where you come at it, I don't think that the primary issue now. Now, if you come at it from the perspective of, no, we promised to the people that we're going to bring manufacturing back to the United States, that's kind of a different question. But then you want to ask whether that's just talk or is it real? And you can even have strong incentives that will increase employment in the United States without bringing new business. So yeah, it's there's so many moving parts in that question, and whatever course you take, you don't control 100% of it, and this is really the problem here. For me, is the fact that states have not yet realized that they don't just depend on themselves. This is the original sin at the OECD, the ridiculous of having model rules instead of a treaty. This is the original sin of Pillar 2 beyond all the other stuff. And when you do that, then, countries will defect and you create a global policing mechanism. They try to do that in BEPS in some ways. And, China and India said yes, yes, yes. And then they continue to do whatever they wanted. We see DSTs. Where did they adopt DSTs? In Canada and the UK and Australia. These are all countries. The UK adopted it while the UK controlled the OECD process of negotiation. So yeah, this is a very cynical world that we live in. there could be significant impact on the economy at a time where we might expect a downturn anyway.
Thank you, Yariv. Any other questions? Shwedi? All right. So that's a lot to think about. Yariv, thank you for
I think
helping us.
just to comment, I think that what Yerif say here is not, of course, not agreeable to see now, but it's the reality we're seeing now.
Yeah. I mean, we don't need to end in a high note because the reality is not like that. It's definitely not like that, and it's. I started this thing saying that cooperation is gone, and I don't think we can end in a high note this thing because
Yes, because what
that's
we
not
had
the world
from
we're living in anymore.
we had from Blasic, let's say a more legalistic perspective, see well, which arguments could bring before courts. But that's a fact. The states will not follow whatever courts will decide. So to say, it's complicated, this situation.
Yeah, I mean, especially when, I mean, just think about Brazil again. I don't know the details and all of that, but Brazil's decisions and actions, how much serious homework was done in the government when they adopted the rules, etc. You know, how are they going to enforce it? How are, you know, all of that and the compatibility of all of these rules with your already existing quite complex system. I will assume that the homework was not extensive,
What
and I think that's true everywhere else.
what is interesting is that the fact that the US does not adopt IAR allows some Brazilian subsidiaries of US companies to challenge the QDMTT here because one would say, well, you should not challenge because once you challenge here, the tax will be paid elsewhere. But it's not true. The tax will not be paid elsewhere since the US will not charge IIR. Since the UTPR is this moratorium, which will take 2 years for this and so on. So I would dare to say that very
Yeah.
fast, companies will begin to challenge it before courts. And we have a tradition here, Yaniv, of challenging taxes before courts and winning cases.
Yeah. It'll take a while though to have a decision, but yeah, and it's very challengeable. I mean, the way they adopted and the whole issues, starting with legality, but definitely not ending there, is definitely challengeable. It'll take though more than 10 years. That's the thing. So
So do you think the fact that we have the safe harbor and the UTPR essentially postponed by some years in most of the jurisdiction, uh, does that eliminate some of the force of the challenge, or you can still challenge based on the, you know, the
no,
entire legal?
no. It might, I think it might drive the challenge to be done because if we had UTPR being applied, if you had UP countries with IRR, it would make no sense to challenge because you wouldn't pay here to pay elsewhere. And because we have a QDMTT that should be under the safe harbor, you would rather pay it here. And that was the reasoning our IRS and our government had adopted it. And it's a fair point that they made. We don't want to leave money in the table. We do need to have tax revenues. They were in a kind of a OECD frenzy, just adopt a transfer pricing, and we are already there anyway. And they did the homework technically. One cannot say that they didn't. They did it technically, and they wanted to adopt it. I don't think what they didn't factor was that they shouldn't have made the move as early as they did because the thing was not yet in place. And I think they thought, well, Biden said it was. I mean, the US even if they don't adopt, they have the corporate AMT, and guilty is kind of the same thing, which it isn't. And Europe has adopted, and this thing has come to stay. And we need to do it now. We need to do it yesterday. Otherwise, we're leaving money in the table, and money that could build schools here that are going to build schools elsewhere. So that was the rhetoric. And unfortunately, the rhetoric is kind of wrong, we're seeing now. And then if IRR is not a thing on most of the UP countries, then UTPR will probably have the safe harbor extended to avoid fighting Trump and see, Europe is not going to repeal the directive because that's not an easy thing to do, but they want to fight Trump anymore. So you probably extend a safe harbor for some time, and that leaves a vacuum to allow for legal challenging here. And legal challenging here is easy in that scenario because, there is a legality issue. Nobody can deny that. There is a discrimination issue. Nobody can deny that. There might be tax treaty issues that you can't deny, as Blazes was putting. You have Article 7, you might have Article 24.5, arguably on a QDMTT. So there are a lot of angles to legally challenge it here. And companies might go to court if it favors them. The only thing, sure, is how long it will take to have a decision, and if how will they deal with paying or not paying the QDMTT and the whole challenging strategy that they're going to adopt here. But I think this vacuum that we're probably seeing on the adoption, and that's why we wanted to cover adoption by different countries in this course. This vacuum might lead to litigation here in Brazil. It only takes one to litigate the whole thing, but I think more than one will go. And if one goes, more will follow. I think that is probably what's going to happen.
Did they think about adopting a QDMTT instead of the corporate income tax? So just replacing it?
That I don't think that was ever on the table because that would be a bigger switch than they would be able to pass in Congress. And the fact of the matter is that something that they didn't even go through all the technicalities and the impacts and so on and so forth. We have probably a corporate income tax reform trying to come this year or the next. We don't know in which strength the current government will have to move it forward. I think probably they will try to reform the individual income tax before that, and I don't know if they will touch the corporate income tax in this administration. And who knows what's going to happen in the next one. So I don't think they wanted to go that route, and they didn't even consider it. What they wanted to have was, as soon as possible, the OECD stamp of approval of having, the Q approval. And the roadmap is, let's have the Q, the MTT, and after that, we'll have the Q tax credits. So the qualified refundable tax credits is definitely the next thing on the roadmap. And the way they did it, they did already authorize it on the law to substitute current tax incentives that are most relevant to qualify refundable tax credits. So that was basically the strategy. And the strategy kind of ended there. And they passed it through Congress faster than I expected. And kind of, there's this thing, it only affects this X amount of multinationals. Don't even debate it that much. Just go with it. It's a OECD thing, and you have more important issues to care about. And we did it right after we adapted transfer pricing. So it's a lot of OECD stuff coming into our law, and the day after is not going to be as easy as one might think. So that's the scenario. But they didn't think, I guess, and I'm talking in place of the government people, which I don't have authority to talk in place. But I really don't think that substituting the whole thing for a QDMTT was on the table ever. Especially because we do adopt the thresholds suggested under the model rules. We didn't go full crazy to adopt to any company, even without extraterritorial presence. So we kind of stuck to the model. Shwedi, anything to add?
No,
No.
no.
All right.
Yariv,
So
just thank you again for your presence here.
thank you, Yariv. Thank you for your talk. Thank you for accepting. Blazers, thank you for staying with us to the end. It was really a pleasure to have you both here, and surely that enriching the course very, very much. Thanks a lot.
Thanks. Bye-bye.
Bye.
Bye-bye. Have a good weekend.
Oh,
Bye, thank you.
Bye, Yariv. Good to see you.